call on Government Order of the Day number 2.
Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill. Interrupted debate on second reading.
Members, when we were last debating the second reading of the Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill, the Honourable Clayton Cosgrove was speaking and has 8 minutes remaining if he wishes.
I do, sir. Thank you, Mr. Speaker.
The Honourable Clayton Cosgrove.
Mr. Speaker, I want to say from the outset that the Labor Party will support this bill. It is an important bill for the innovators in our community. We know from the statistics that we do not hold enough patents in New Zealand. Patents are extremely difficult and extremely expensive for many of smaller, particularly smaller innovators in our community to protect their intellectual property. But I've got to say, sir, before I do this, I want to thank the chair of the Select Committee, Melissa Lee, for the way she chaired this piece of legislation. She allowed a lot of latitude to examine its content and particularly the officials. And, sir, normally I would not criticise public servants. I think we have a world-class public service, but I have to say, sir, if you read the report from the committee, not just the minority report from the Labor Party, but actually words which are consensual, if you like, between the parties on the Select Committee, I have to criticise absolutely the process, sir, of this. This bill, sir, set out to facilitate the development and implementation of a single patent application process and a single patent examination process in respect of the Intellectual Property Office in New Zealand and its equivalent in Australia. We enter the Select Committee, something, sir, that the Labor Party supported. It was a government proposal, like many of the Trans-Tasman amalgamations that we've had in respect of the law and accountancy, greater efficiency, sir, ease of access for the industry, etc., etc. We then got some concern from the patent attorneys, sir, and I have to say from a couple of the big end of town, Fisher and Paykel and others who are involved in serious innovative work, that this would be detrimental to the industry, sir. And if you go and look at the report, it talked about the lack of benefits to business and patent attorney firms making applications on their behalf, that there'd be a small cost perhaps and time savings. It goes on to say it talks about increased administration costs to business. It talks about significant costs in other ways, sir. And then we get to the heading consultation and quantification of costs. All those criticisms, sir, which has led the government to gut the bill, to reverse its original proposal, to do away with the Trans-Tasman amalgamation, sir, on the basis, and I don't actually criticise the minister. He had a chirp there. I don't criticise him. In fact, I'm on record, Melissa Lee will verify this, as saying I felt sorry for him because if he was served up the drivel, sir, that we were served up by officials to the minister, it was almost impossible for the Select Committee to make a recommendation, but he was served up, I think, sir, grossly inadequate advice. There was no quantification of costs, sir, in respect of costs and benefits. In fact, officials came to us, and I wrote this down. It took us, I think, 2 meetings to get it out of them. We asked them, have you quantified the costs? Have you gone and talked to industry about this? Answer, oh yes, no, well maybe, we'll come back to you with something. The following week, sir, they came back to us with nothing written down, but I wrote this down. They said, they gave us a figure, I think $500,000 in respect of some of the costs. How did you come to that, we asked? That was, quote unquote, our best guess. Quote unquote, back of the envelope. These officials told a Select Committee. Sir, the process was so bad that at one point, thankfully, unusually, but thankfully, the minister's own advisor came and attended a private session of the committee, which I welcomed, and I think all members of the committee welcomed, to give the minister feedback on the lack of adequacy in respect of this bill. It talks, sir, if you look at the paragraph, consultation and quantification costs, and this is a paragraph, sir, written by the committee as a whole, supported by, I think, unanimously by all parties. It says this, quote, we consider that the lack of consultation with patent attorneys and the rest of the industry, because of course MB didn't consult the innovators, the small guys and girls, the small end of town, sir. The Labor Party actually went out and talked to some of the universities and others and to innovators. They talked to a few at the big end of town, Fisher and Paykel. I make no criticism of Fisher and Paykel, but they didn't actually talk to the innovators, many of whom, sir, struggle to access patents and protect their intellectual property. It goes on, sir. there was a lack of consultation with patent attorneys and the rest of the industry before the development of these proposals, of these enabling provisions. Moreover, we consider the quantification of likely costs, that is the costs of developing and implementing these processes, and the compliance costs to the industry and patent applicants was inadequate. Sir, as I say, I don't often criticise those in our public service, but I suspect other members will join with me in that criticism, sir. The pre-consultation process was hopeless. At one point, officials basically said to us, when we asked and dug into the costings and the lack of costings and lack of quantification and the reason for the reversal of the government's own proposal, we were basically told at one point, well, the industry, and by that they meant patent attorneys, the industry is wider than that. It goes to the patent attorneys' clients, the innovators who require this form of patent protection, sir. We were told basically they didn't like it and trust us being the officials, because they have heavy-duty so-called expertise in this, sir. So I've got to say, and I do say it with seriousness, and I did say to the officials, if this is the sort of rubbish and lack of analysis that you served up to your minister, well, I actually feel sorry for the minister. And I mean that in all seriousness. I did say it. And we actually said to them, go back, talk with the minister, and the minister, you know, has made some decisions in respect of this, sir. So, sir, whilst we support it, I can do no better than reading the last paragraph of the Labor Minority Report that says this: Labor will vote for the proposed amendments, but we remain bemused at the dexterity required by the government to justify a complete reversal of its original position. So this is a bill that should have gone out to the industry as a whole. It is the industry that knows best about this, but I think officials just felt, we'll just fire this one through. The amount of time and money that's been wasted to dish up an inadequate piece of legislation, badly drafted, to then put that before a select committee, sir, and then for the government's own officials to come in and say, we want to reverse what we originally put to you. Not just a minor tinkering in the odd amendment, but the major part, the Trans-Tasman amalgamation, if you will, sir, of the processes around patents. Now, it may well be valid. I say we support it, sir, but I have to say, given the lack of analysis and advice we had, I've got to say that the jury's still a bit out. We'll see how this goes. But I just say to the government, and this is bubbled up in a number of pieces of legislation, where bad advice, badly thought out legislation has been served up, and actually, and to the credit of national members on the committee, and New Zealand First members and others, collectively, we took a long time to examine it and pull the facts and the truth from officials, and we've done our best, I think, and thanks to the chair, to put a bill, to sort of put Humpty Dumpty back together again, and to put a bill before the Parliament, sir, that I hope will serve the industry, not just the big end of town, sir, but those innovators, the patent attorneys' clients, who need this sort of legislation to work and work well.